Thank you, Mr. Chairman. On June 2nd, Congressman David Schweikert and I held a joint field hearing in Arizona on the EPA's proposed rule to expand the definition of navigable waters of the United States. 5 members of Congress, including Lamar Smith, Chairman of the House Science, Space, and Technology Committee, participated in the hearing, and we heard testimony from 9 Arizona witnesses. That hearing provided some great insights in regards to real people in Arizona who will be negatively impacted by a rule made here by bureaucrats in Washington, D.C. Let me highlight some of those. Stephanie Smallhouse, testifying on behalf of the Arizona Farm Bureau, testified that the newly proposed EPA rule for waters of the U.S. would be devastating to my family's farming operation, as well as hundreds of others in agricultural communities in Arizona. This proposed rule is an economic disaster and a dream killer for my kids. Bob Lynch, a very accomplished water attorney, testifying on behalf of the Irrigation and Electrical Districts Association of Arizona, said, "The EPA and the Corps have driven a truck through Justice Kennedy's opinion in Rapinos. This may be the biggest jurisdictional overreach I have witnessed in 50 years of law practice. I hate to say it, but the only people who come out ahead on this proposed rule are lawyers. Just like the hearing we're holding today, the agencies were invited, and just like the hearings we're holding today, not one agency official showed up to hear from real people or answer questions about the proposed rule. I want to make sure that all the people who took the time and effort to participate in the 3-hour June 2nd Arizona hearing have their voices heard. Mr. Chairman, I'd like to ask permission to submit the witness testimonies and statements from the hearing for the congressional record.
Without objection.
I do have a few questions that I would like to take a time to ask. Now, the waters of the U.S. proposed rule directly contradicts aspects of 4 U.S. Supreme Court decisions. These decisions have restrained federal agencies and imposed limits on to the extent of federal Clean Water Act authority. Mr. Martin, Mr. Terrell, Mr. Parker, and Mr. Clark, do you believe the EPA is overreaching with the waters of the U.S. proposed rule in regards to the Supreme Court?
Correct. I do.
Yeah. Thank you. Now, Mr. Lumley, are you familiar with the Constitution?
Yes, sir.
And the law of the land is held by what? Last jurisdiction would be what? Would it be the Supreme Court?
Yes, sir.
Are you kind of taken back that there were 4 decisions that contradict this expansion of power? Does that kind of concern you?
No, sir, it doesn't.
Really? Whoa. So the law of the land, the Supreme Court, jurisdictionally is number uno, right? You just said that. So that doesn't bother you that you're surcepting, that the federal bureaucracy is surcepting the Supreme Court. That doesn't bother you. I think that's interesting. Mr. Tyrell, you testified that the authority for the proposed directive on groundwater management does not exist. If there is no statutory authority that exists, how does the federal government satisfy asserting federal reserve rights to groundwater?
Mr. Chairman, Representative Gosar. Thank you. The only time I've seen a federal reserved right asserted in any type has been either through congressional action or through the result of state or Supreme Court litigation or settlement. I've not seen it asserted as policy before, and that was troubling to me.
Especially in light of what I just cited. Mr. Tyrell, you also testified that the Forest Service groundwater directive will harm states' rights and negatively impact your state's water users. At a time of extreme drought in the West and scarce water resources, how concerning is this directive, and can you elaborate on some of the possible consequences for state and private water users?
Mr. Chairman, Representative Gosar, yes, the concern number one would be timing. We have, to the extent that directive would delay or impact anybody being able to get a permit on the forest if they are not the forest, and we do issue permits to grazing permittees, water right permits to grazing permittees for wells, stock ponds on forest property. I do not know the impact at this point of the groundwater directive on those people's ability not to get my permit, but to get the ability to build it on their allotment. Secondly, the purported connection or the presumed connection of groundwater to surface water has impacts that we can't see. If that connection, which is contrary to Wyoming state law, by the way, which we presume that groundwater and surface water are separate until they are shown to be connected, and then we regulate them in that way. If the connection is presumed to exist, there could be effects on surface waters and the regulation of those surface waters and work on diversions, et cetera, because of the groundwater connection. That's a concern of ours.
Well, in Arizona, this is the same way. We have some delineation just like does Wyoming, so we do have the same concept of oversight. So thank you, Mr. Chairman. I yield back.